Hi, I'm Wil Burns, and I'm the co-director of the Forum for Climate Engineering Assessment, which focuses on climate geoengineering issues, but that's not what I'm going to talk about. So my friend Dave Hawkins at NRDC has said that when we look at climate change issues, there's no such thing as a silver bullet, but there's lots of silver buckshot, and that's how I view how we address climate change. And I think one of the more potentially potent kinds of buckshot is climate litigation. I'm a law person by training, and so I just want to talk briefly of where I think in the Trump administration litigation may have a role, and the fact that we should consider when we're looking at things to funding organizations, especially NGOs such as Earth Justice in San Francisco, that are working on climate litigation. And there's a number of these potential causes of action that are percolating and are likely to grow stronger as the Trump administration begins to mobilize and seek to destroy the edifice of climate legislation in this country and international treaties. The first of these is something we call atmospheric trust litigation. Atmospheric trust litigation is based on a Roman doctrine called the public trust doctrine that's been embraced in the United States and a lot of other countries. It's the argument that the government preserves natural resources on behalf of this generation and future generation. It has an obligation both to protect those resources in specific manners that are carved out by the courts, and perhaps as important, to repair past damages. There's been a number of public trust cases throughout the world, including in Spain, Portugal, the Philippines, et cetera, that have successfully protected public resources. The atmospheric trust doctrine seeks to extend that to the context of climate change and argues that we should view the climate as an atmospheric trust. The case that you've probably heard of the most, despite the fact there's a number of state cases, is a federal case called Juliana versus the United States. And this was brought by a group of children, grade school children through high school, with the work of a law professor at the University of Oregon. That case very recently was able to withstand a motion for summary judgment in a federal district court in Oregon, which means it is going forward, and it will argue that there is a public obligation, a federal government obligation to protect the climate, and that the federal government has a responsibility to carve out specific remedies, including reparative remedies. And I would suggest that that's the litigation that we should be supporting, for a couple of reasons. One, I think it might actually prevail. Second of all, perhaps as important, is litigation also can have a potent symbolic role. It can help us to change norms and to convey the importance of issues. When we talk about communications, the law, for better or worse, has a great cachet. And the fact here that we have children who are literally fighting for their future provides us a very potent narrative that may be one of the best narratives we have when we move forward. Another possible avenue of litigation is something called public nuisance. Quintessential case of public nuisance is when you have a polluting facility of some sort, such as a metallurgy plant that creates major damage throughout an area. Public nuisance cases have been brought in the past in terms of climate change. We did an entire book a number of years ago on this, 2005 through 2008. Most of those cases went down in flames for a couple of reasons. First of all, courts found that we didn't want to interfere with the federal government's efforts to negotiate in good faith at the international level to address climate change. And second of all, once we started in the Obama administration carving out remedies under the Clean Air Act, once the Supreme Court said that we could regulate greenhouse gases under that, courts began to argue that public nuisance was preempted by statutory remedies. That may all change in the Trump administration. First of all, we may no longer, as courts, indulge the fiction that the Trump administration is working diligently at the international level to negotiate effective climate agreements. And to that extent, we may find courts, especially before they've been packed with Trump appointees, more amenable to this kind of argument. Second of all, if the Trump administration is successful in dismantling the Clean Power Act, Clean Power Plan, which he very well may be, perhaps reversing the finding of an endangerment and thus removing federal authority under the Clean Air Act to regulate greenhouse gas emissions, then this preemption of public nuisance actions by federal legislation will also fall to the wayside, and there'll be fertile ground for this kind of litigation. And so I would argue that one of the things that we should be looking at in terms of our financial support are organizations that are effectively waging those battles. And as I said, Earth Justice, the Center for Conservation Biology, and some others are doing that kind of work. There's other areas also we should consider funding. There's a number of causes of action right now under the National Environmental Policy Act, which mandates environmental impact statements, that is fighting federal leasing of federal land for fossil fuel development tract by tract. And one of the important things about that is it's working to hone this idea of the social cost of carbon and feeding that into the environmental impact statements. One of the things that the Trump administration has targeted is the social cost of carbon to try to discount it. Effective litigation, discovery that helps us to bolster the arguments in terms of support of the social cost of carbon will help it make it more difficult for them to do that from a statutory standpoint, also and in terms of this litigation. And then finally, the other thing I think we need to be doing is working on the Clean Power Plan litigation. 27 states have brought an action against the Clean Power Plan, our only federal efforts to address climate change. Circuit Court in D.C. is going to decide that case later this year. Invariably, either way, it's going to go to the Supreme Court, probably with a Trump appointee on it. It may be likely that that case throws out most of the Clean Power Plan. But if the Clean Air Act is still in place and it still requires federal regulation of greenhouse gases, then there's going to be a rulemaking process. And one of the things that's important for NGOs and organizations such as this is to support effective efforts to ensure that if new rules are put in place, that they do not eviscerate the kind of things that we've developed. And there's standards from a legal perspective that may limit how much damage the Trump administration can do. And we should certainly be fighting to do that. Thank you.